So it's my pleasure now to introduce our next speaker. And this is our guest from overseas, Judge Peter McClellan. Judge McClellan is the chair of the Royal Commission into Institutional Responses to Child Sexual Abuse. He is the Judge of Appeal in New South Wales, and prior to this, Judge McClellan was the Chief Judge at the Common Law of Supreme Court in New South Wales, having been appointed to that position in 2005. Judge McClellan became a member of the Order of Australia in 2011 for services to the judiciary throughout the Supreme Court of New South Wales, to environmental law and his work to legal education. Please join me in welcoming Judge McClellan and his keynote speech this morning. Thank you, Judge.
Tēnā koutou and good morning. I'd like firstly to acknowledge the local iwi, Ngāti Whātua. I like New Zealand a lot. My wife and I have been going to the South Island every year in January for as long as I can remember. But I have a closer connection. There was a large part of me that was barracking for New Zealand on Sunday. That's because two of my children, when they were young cricketers, were coached by McClellan. Brendan came to Sydney before he was the New Zealand wicketkeeper, but he'd been recognised as having that potential. And he worked with Steve Rickson, who was then the coach of the New South Wales cricket team, and to earn some pocket money, he coached young kids. And you may have gathered, he made a very significant impression on me at that stage of that young man's life. I didn't quite realise how good he was going to become, but I can tell you my heart dropped on Sunday afternoon when I saw him go so early in the innings. I wasn't quite sure whether New Zealand should have won, but gee, I would have liked them to have come within one run. The Royal Commission, of which I'm the chair, has now been in operation for more than 2 years. We've completed the public hearings for 25 case studies, which in most cases have been concerned with the failure of institutions to manage their affairs to adequately protect the children in their care. We will be able to complete in the time given to us about another 25 case studies. I in fact have enough information to carry out more than 1,000 public investigations of Australian institutions, but inevitably we won't be able to do that. We have so far looked at churches, religious schools and state-run institutions. We also recently looked at issues in relation to out-of-home care, of course the contemporary location for many of the problems that we've been required to look at. But we have many more and varied tasks to complete. One of the obligations in our terms of reference requires the Commissioners to consider what institutions and government should do to address or alleviate the impact of past and future child sexual abuse, including in particular in ensuring justice for victims through the provision of redress by institutions, process for referral for investigation and prosecution and support services. In other words, a large part of the criminal law. Justice for victims is an elusive concept. In the civil context, redress schemes providing modest money compensation without the need to prove a breach of a duty of care are commonly believed to be appropriate. Otherwise, in the civil context, there are difficulties in defining the content of a duty of care. Determining the individuals or institutions who must accept the obligation of fulfilling that duty can also provoke animated discussion. Whether common law damages or some more confined financial recompense is appropriate are matters the Commissioners are considering as part of our discussion about redress for survivors. Justice for victims in the criminal context raises multiple and complex issues quite different from those which are relevant to the civil context. The Royal Commission is addressing many of those issues through external research, roundtables and our own policy development. Professor Ari Freiberg and Hugh Donnelly, who I think are talking to you at some stage, and others have already completed significant work for the Commission. The issues extend across the appropriate range of criminal offences, the reporting of criminal acts, their investigation and their prosecution. The latter requires us to consider the trial process, the legal rules which control it, in particular joint trials and tendency evidence, directions to juries and appropriate sentencing outcomes. The Royal Commission, like any Royal Commission, is in a privileged position. We are able to both undertake and also commission other professionals to conduct empirical research to inform our decision-making. But what of the judge in whose court the criminal trial is conducted? The question I will explore today is how knowledge developed in disciplines outside the law, that is, the knowledge which I know many of you in this room have, who are not lawyers, but which is relevant to determinations which the lawyers make. The question is, how can your knowledge as professionals be communicated to and appropriately used by judges? Although relevant to all judicial decision-making, it has particular relevance in the child sexual assault context. Today's discussions will not be the last I will have to say on this topic, but it provides me with an opportunity to raise issues which we will seek to discuss with the community going forward. Although I speak with an Australian voice, I recognise the issues also have a New Zealand perspective. The fundamental problems are the same in each country. My purpose is to challenge all of us to reflect on how it is that the law can use the work of the scientist to the greatest benefit of the whole community. The rule of law is a fundamental concept which underpins the social compact by which we order both our societies. It is important to stress that although the concept necessarily contemplates legal rules, it must be distinguished from the notion of rule by law. Rules are necessary to govern a society which accepts the rule of law. The question is always, do we in fact have the appropriate rules? If confidence in the rule of law is to be maintained, it is necessary for the legal rules to reflect the contemporary knowledge and expectations of the community. Those expectations are born of generally accepted values. Some of those values are reflected in our trial processes, which are informed by contemporary understandings of human behaviour. With time and greater knowledge, our understandings are modified or redefined. And therein lies the challenge for those who seek to make the rules, be they legislators or judges. Early in the development of the common law, the task was relatively easy. It is now much more difficult. In the mid-1700s, the famous English jurist Sir William Blackstone discussed the common law approach to a provoked killing. His words reflect the values of the 18th century. They actually sound a little quaint, but nevertheless resonate today. He said, if a man be greatly provoked, as by pulling his nose, well, I don't know what happens at a rugby match, or other great indignity, and immediately kills the aggressor, then the law paid regard to human frailty, and the killer was convicted of manslaughter. I'm not sure that the nose would justify that finding today, but there we are. If, however, he said there was sufficient cooling time for passion to subside and reason to interpose, then the defence would fail and the killing would be murder. Contrast the contemporary relevance of those words, and of course they are, about provocation with Blackstone's understanding of the mind of a victim of sexual assault. Now remember, he's talking in the middle of the 1700s, and he said, if the witness be of good fame, if she presently discovered the offence and made search for the offender, these and the like are concurring circumstances which give greater probability to her evidence. But on the other side, if she be of evil fame and stand unsupported by others, if she concealed the injury for a considerable time after she had the opportunity to complain, if the place where the fact was alleged to be committed was where it was possible she might be heard and she made no outcry, these and the like circumstances carry a strong but not conclusive presumption that her testimony is false or feigned. The seeds of later and fundamentally erroneous approaches to issues of sexual assault can now be seen in those remarks. In 1879, an event occurred of fundamental importance in the development of our understanding of human behaviour. In Leipzig, the first laboratory solely dedicated to psychological research was founded by Wilhelm Wundt. In that laboratory, Wundt and his students developed the empirical methodologies that allowed psychology to emerge as a discipline distinct from philosophy. The question was, how would the law respond to the birth of the new science, whose area of focus, human behaviour, was central to so many aspects of the law itself? Initially, matters moved relatively quickly. Less than 2 decades after the formation of Wundt's laboratory, a murder trial in Munich saw what was probably the first testimony given by a psychological expert. And in Vienna in 1906, Freud gave a series of lectures to judges discussing the lessons that psychology might offer the law in the context of fact-finding. Despite these promising beginnings, by 1908, it was evident the law was largely indifferent to the way in which psychology might be applied within its domain. That year, Hugo Münsterberg, who had been a student of Wundt's in Leipzig, before moving to the United States to run the psychological laboratory at Harvard, published a book entitled On the Witness Stand, Essays on Psychology and Crime. Münsterberg was a strong advocate of forensic psychology and in particular psychological testimony. He had himself served as psychological consultant in 2 murder trials in the US. In his book, Münsterberg described how experimental psychology had sufficiently matured to the point where it could now be deployed to serve the practical needs of life: education, medicine, art, economics and the law. But whilst the other disciplines had embraced psychology, he said of the law, the lawyer alone is obdurate. The lawyer and the judge and the juryman are sure that they do not need the experimental psychologist. They do not wish to see that in this field, preeminently applied experimental psychology has made long strides. They go on thinking that their legal instinct and their common sense supplies them with all that is needed and somewhat more. As far as the law was concerned, human behaviour was directly observable. Our common sense, together with the judicial wisdom derived from legal experience, was more than adequate. This sentiment is captured in the words of Lord Justice Lawton, who said jurors do not need psychiatrists to tell them how ordinary folk who are not suffering from mental illness are likely to react to the stresses and strains of life. I wish I had such confidence myself. Despite the advances psychology was making and the insights it was generating, judges continued to rely on their own observations and assumptions about human behaviour. The evidence of children, for example, was to be treated suspiciously because of the possibility of a young child having a mistaken recollection about what happened. Nothing, of course, was said about the recollections of adults. Standard legal texts contained quasi-psychological explanations of criminal behaviour, discussing the relevance of post-offence behaviour to a determination of guilt. Justice Kirby, a well-known Australian High Court judge, referred to the 1940 writings of Wigmore. Now, Wigmore, to the lawyers in the room, is well known, but to others, he's one of the great heroes, as it were, of the middle 20th century in the common law. Wigmore hypothesised that just as the commission of crime leaves, quote, traces of blood, wounds or rent clothing, which point back to the deed done by him, it will also leave, he said, mental traces, which will manifest in subsequent conduct of the criminal. Psychology and psychiatry grew rapidly after the Second War. Many judges, however, continued to rely on their own assumptions about how people behaved. One area in which this is particularly evident is in assumptions judges make about how jurors reason. For example, it has been held that a judicial direction is required where there is evidence that the accused has lied, because there is, the judges say, a natural tendency for a jury to think that if an accused is lying, it must be because he is guilty, and accordingly to convict him without more ado. Similarly, the rationale for trying multiple counts separately, one of the issues that plagues the area of sexual assault, was held to be the real risk to an accused person, which may arise from the adverse effect which evidence of his implication in one of the offences charged in the indictment is likely to have upon the jury's mind in deciding whether he is guilty of another of those offences. Judicial assumptions about human behaviour are still in relatively contemporary times informing the content of the law. Some of these assumptions, of course, may be sound. Some accord neatly with a common sense view that would be prevalent in the wider community. But how do we know, absent direct consultation of relevant empirical material, if it exists, that these assumptions are correct? It may well be that at the time many of these assumptions were developed, there was no objective material of professional learning that could be consulted. But what is to happen if subsequent knowledge casts doubt upon assumptions that have found their way into the content of the law? How should judges keep abreast of wider scientific developments relevant to the judicial task? And how then should they make use of them? And what does the law itself have to say about how judges might appropriately undertake this task? In essence, the question to be asked is how should we frame the contemporary rules of what lawyers call judicial notice? Judicial notice is a doctrine which allows judges to draw on their own knowledge when deciding the facts in an individual case. It also allows them to deploy their knowledge of the world when developing the law. It sets the limits on the capacity of courts to consult material not tendered in evidence to undertake both those tasks. Judicial notice is an exception to the rule that information that is to be relied on in the determination of material facts, that is, the facts in issue, which lawyers call adjudicative facts, must be proved by admissible evidence, evidence that is tendered and subject to cross-examination. Rather, relevant information need not be tendered and may be acted upon either simpliciter because it is well known and indisputable, or where it has been appropriately verified. The search for consistency in the application of the common law doctrine of judicial notice to fact-finding, at least in Australia, is destined to complete failure. The application of the doctrine by our High Court itself has been described as erratic, with the criticism made that many of the cases appear to have departed from the principle in pursuit of convenience. This reflects the difficulty which the law has encountered in providing rules which allow relevant learning in other disciplines to be utilised by courts when making decisions. Since the introduction in Australia of uniform evidence legislation, and you have a similar approach here in New Zealand, provisions in those acts govern the principles of judicial notice. In our Act, the key section is section 144. It provides that proof is not required about knowledge that is not reasonably open to question. If that condition is satisfied, then the knowledge must also be either common knowledge or knowledge capable of being verified by reference to an authoritative document, which cannot be reasonably questioned. Section 144 also provides that judges may acquire this knowledge in any way they see fit. It responds to procedural fairness concerns by providing that the judge is to give a party an opportunity to make submissions and refer to relevant information relating to the taking into account of knowledge of this kind to ensure that they are not unfairly prejudiced. It is important, at least in the Australian context, to appreciate that the judges of our High Court have now said that there is no room for the operation of the common law doctrine of judicial notice. If judicial notice at common law was unsatisfactory, incorporating it into the statute has proved highly problematic. Such an approach presents a serious impediment to any dialogue that might be had between the law and science. This particular problem in these terms has been, I think at least partially, avoided in New Zealand, but nevertheless the underlying difficulties remain. In 1955, the rules which govern judicial notice were brought directly into focus by attempts in the United States of America to codify the law of evidence. That year, the American legal academic Kenneth Davis published an article which he called Judicial Notice in the Columbia Law Review. His purpose in writing was to express his concern in America that the proposed model code of evidence was, in his view, seriously and fundamentally unsound. Davis recognised that courts use facts not tendered in evidence before them in two ways. The first is to determine the facts in issue in a case, which he called an adjudicative fact. They're the sort of facts we're all familiar with. The second was the way in which facts are used in assisting the court to determine the content of the law, and more particularly the policy that the law should use, and how to exercise its judgment or discretion in determining what course of action the law should take. He described these facts as legislative facts. Davis was concerned that the distinction between legislative, those which tell you how to decide something, and adjudicative facts, the evidence in the particular case, had not been sufficiently recognised in America. This was problematic because incorporating legislative facts into the judicial notice provisions placed a fetter on the ability to draw on outside knowledge in circumstances where the formulation of law and policy gains strength to the extent that information replaces guesswork or ignorance or intuition or general impressions. Questions of law and policy, he said, often yield to comprehensive factual study. Now, these distinctions between legislative and adjudicative facts have been discussed in Australia in similar terms, and I won't trouble you with that discussion this morning. Justice Hayden, though one of our judges, has described legislative facts as revealing how existing rules work and how rules which do not exist might work if they were adopted. Any discussion of legislative and adjudicative facts raises multiple dilemmas. Reasoning processes which apply when determining a fact in issue, that's a fact in the case, may be a result of the application of legislative fact authoritatively determined and used to inform a rule. We may also, and often do, instinctively apply our own accumulated knowledge to determine a fact in issue. We all do this, of course, every day. In reality, we may be applying our own formulation of legislative facts to aid the resolution of the facts in issue. And when we look at what people instinctively assume, we may be in for a surprise. In a paper published in 2006, I discussed the process by which a person may determine facts in issue, that's the facts in the trial, including the behavioural characteristics by which many people believe they can identify and distinguish a truthful witness from someone who is telling lies. The research I examined for the purpose of that paper indicated that despite the assumption that observing the demeanour of a witness under examination, in particular under cross-examination, will assist the tribunal of fact in determining whether the witness is truthful, for most people the likelihood of a person detecting a lie or detecting someone who is lying is actually no better than chance. Importantly, it is not just the jury who will struggle with this task. There is evidence to the effect that judges and lawyers fare no better than lay people in their ability to detect someone who is lying. This inability to accurately identify a falsehood may be explained by what psychology tells us are the behavioural cues that do not indicate dishonesty, cues which run counter to many commonly held assumptions. Shifting posture, smiling, scratching and head, foot or leg movements are not the hallmarks of a liar. And while most observers rely on a person's face to assess their credibility, this, the psychologists have conclusively demonstrated, is in fact the easiest behavioural channel for a person to control. I concluded in that paper that acceptance that precepts of common sense applied to decision making will lead to an understanding of the real truth may be at odds, indeed sometimes markedly at odds, with what science may tell us about the observed behavioural characteristics. The Royal Commission, which I chair, is of course concerned with sexual offending, particularly in relation to children. The history of sexual assault trials and the legislative facts, the rules surrounding them, relevant to them, are replete with statements by judges which reveal ignorance of the learning available in the relevant field. Now, I'll take just some of these. I'll try not to emphasise any one in particular, but you can choose for yourself. Quote, this is a judge talking. If events such as these occur, one expects some complaint to be made, and that such a complaint is made within a reasonably early stage of the events themselves. Take, for example, an allegation that someone was raped, and the complaint is made a year later. That, in the eyes of everybody, underline, would cast some suspicion on the acceptability of the allegation. The second one. There is, of course, nothing wrong with a husband faced with his wife's initial refusal to engage in intercourse and attempting in an acceptable way to persuade her to change her mind. And that may involve a measure of rougher than usual handling. Sometimes it is a fine line between agreeing, then the changing of mind and consenting. Number 3. Experience has shown that human recollection, and particularly the recollection of events occurring in childhood, is frequently erroneous and liable to distortion. 4. It is really dangerous to convict on the evidence of the woman or girl alone. This is dangerous because human experience has shown that in these courts, girls and women sometimes tell an entirely false story, which is very easy to fabricate, but extremely difficult to refute. The next one, a complaint is admissible if made at the earliest reasonable opportunity. If a man runs out of a house and doesn't tell anyone the house is burning until the night following, it is not consistent with him believing that the house was on fire when he ran out of it. And finally, and this is a quote from a trial in 1995. Quote, there is no evidence, apart from the evidence which she gave, that is the complainant, which corroborates or significantly confirms what she told you. her evidence is not evidence of the truth. Now, the law in relation to legislative facts in Australia has been rendered uncertain by a decision of our High Court in a case called the Tuggerel, which for those Australian lawyers in the room would probably by now be a familiar name, but it's certainly the subject of considerable controversy in Australia. I have to disclose that the appeal was from the New South Wales Court of Appeal, where I presided. I dissented, and the High Court ultimately didn't agree with me either, but there you are. I referred directly, it was a case about DNA and how you should refer to DNA in the course of a trial. A very important subject, given that DNA evidence is now the dominant force in any criminal trial. If there's DNA that's relevant to the accused, you can almost see the jury's eyes shut and they don't want to hear any more. Anyway, this was about how you talk about DNA, and I referred directly to research undertaken into the persuasive power associated with different forms of expression of statistical information. The information was being relied on not to determine a fact in issue. Rather, it was relevant to the jury's consideration of the DNA evidence, and in turn, how the rules relating or related to the exclusion of that evidence might be applied. The consequence would be how the advocates could explain the evidence in submissions to the jury and how the judge would direct them in relation to that issue. That, of course, is a legislative, one of the rules of the trial, as opposed to an adjudicative fact. The High Court decision has come to be understood, at least that of the joint judgment, as excluding recourse to legislative facts unless determined in accordance with the rules of the Evidence Act. Justice Hayden was the one judge who suggested that that may not be right. If it is right, it becomes a very significant constraint on how the judges can use the learning of all of the other professions in devising the rules which the common law should adopt. It also represents a significant shift in the approach of the judges. There was a previous case called Woods in which Justice McHugh, now retired but a very respected High Court judge, said that there were countless occasions when justices of the High Court have used material extraneous to the record in determining the validity and scope of legal rules and principles. He said they have frequently relied on reports, studies, articles and books resulting from their own research after the case has been reserved and parties have made their submissions. His Honour went on to cite examples of reference to extraneous materials, and in particular he referred to material which he'd read about why children may delay in complaining in sexual assault cases. Now, there's another case called Doggett in which Justice Kirby, again the same Australian judge, said when discussing why judicial warnings were required in cases involving sexual offences, that it would not be ordinarily expected that jurors would be aware of the findings of experimental psychology or of the common experience of forensic contests and other data supporting the reflections about memory. Judges, on the other hand, he said, as opposed to jurors, are or should be aware of such matters. That is why he said in the case of long delay, a warning was required to be given to the jury. I'll come back to that warning in a moment. But there are two judges, now admittedly 20 years ago, saying they expected other judges to have regard to the learning of psychologists when they came to frame the directions to the jury as to how the jury should assess the evidence of the witnesses in that case. What's now happened later on is the judges seem to be saying, no, you can't do that. And the question that we confront in the Royal Commission is just what should be the rules? Should we be recommending to government that the rules change so that there is a mechanism whereby the learning of all of you who aren't lawyers but relevant to the tasks which the lawyers must perform in the trial process, can have your learning taken into account. Ordinary human behaviour, as the lawyers like to call it, whatever that is, has been recognised as a particular category of facts that may be judicially noticed without evidence, that is, without reference to external material. Justice Gaudron, who was the first female judge of our High Court, observed that child victims of sexual assault may be reluctant to resist the offender or to protest, and reluctant also to complain for fear that they may be rejected or punished by the offender. Now, it's significant that such an observation could be considered so commonplace and well known to fall within the exception of judicial notice. But, of course, what Her Honour was saying, and that was in 1994, was contrary to decades of long legal practice in respect of the absence of complaint, which assumed the very opposite. And I'll come back to that in a moment. What material falls into and outside of the category of ordinary human behaviour will largely be a matter for the individual judge. It is a topic, of course, about which reasonable minds may differ. Consider, as an example, differences in the way judges approach their capacity to know how teenagers behave. And I defy any adult of my age to actually, even though I've got 4 children, to know how teenagers behave, but nevertheless, in one Australian case, which was an appeal against conviction for a number of sexual offences committed against a complainant who was 13 years old at the time of the offences, Justice McHugh expressed doubt as to the capacity for judges to assess teenage behaviour, stating, quote, "Attitudes towards sexual matters and behaviour of young people have changed so much in recent years that in many instances the views of appellate judges about how teenagers behave, derived from their own past conduct with teenagers, may well be out of date." Well, I can assure you I think mine is, but there we are. However, the contrary position was taken by the High Court again in another case, Phillips it was called, which was a tendency case where the court relied on its own assessment of how teenagers normally behave to determine that the accused's behaviour on other occasions was not sufficiently unusual and therefore not sufficiently probative to justify its admission. This decision precluded the jury from making its own assessment of the behaviour of the accused and its possible probative value. Now, that's a very important case because the behaviour in question was the modus operandi of an alleged offender who was a teenager in his seduction, if it can be called that, of teenage girls, and how he operated in bars to separate them from their group and persuade them to come with him, and then ultimately it was alleged he sexually assaulted them. And what the court was saying is that it knew that, effectively, that many teenagers behaved in the same way, and accordingly it was not appropriate to tender evidence of how this fellow had behaved on some occasions in order to bolster the Crown case that on this occasion he'd behaved in the same way and it had led to an assault of the teenage girl. I think the average age of the High Court judges at the time was probably 64 or 65, when they were talking about the behaviour of 14-year-olds. Another judge who was cautioned against judges relying on their own assumptions about modern society is Justice Callanan. He observed that an assumption of such a kind may be unsafe because the judge making it is necessarily making an earlier assumption that he or she is sufficiently informed or exposed to the subject matter in question to enable an assumption to be made about it. Ordinary human behaviour is, of course, fundamental to the study of psychology. Although our current rules have been framed by judges, drawing upon their own understandings, however misguided they may be, our statute now prevents consultation of authoritative professional material on potentially the same topic unless that information is brought to the attention of the parties, and only where it is not reasonably open to question. This has significant implications for both the civil, but more particularly, as I've attempted to explain, the criminal trial process. The history of the legislative facts relating to delayed complaint in the context of sexual assault, be it a child or an adult who is assaulted, illustrates some of the problems. Embedded within the common law were special rules for dealing with complaint in the context of sexual assault, in particular in circumstances where there was a delay between the occurrence of the assault and the time at which a complaint was made. The common law, laid down in a case called Kilby, required a judge to warn the jury that delayed complaint was irrelevant to the jury's assessment of the credibility of the complainant. The rationale for this rule was the general assumption that the victim of sexual offences will complain at the first reasonable opportunity, and that if that complaint is not then, and that if complaint is not then made, that is at the earliest opportunity, a subsequent complaint, the law was required to assume, is likely to be false. The common law equated delay with falsity because of how judges assumed genuine victims of sexual offences behaved. The assumption was derived from the medieval doctrine of hue and cry, and it was an assumption, this audience won't be surprised to know, which was framed by male judges. Research has thoroughly discredited this assumption. Delay in complaint is in fact typical rather than unusual, particularly in the context of child sexual abuse. Evidence indicates that a majority of children who are sexually abused do not reveal this abuse in their childhood at all. Research has eroded any factual basis on which a general requirement to direct a jury that delay is relevant to credibility could have been justified. In response to concerns about the stereotypical assumptions contained in the common law, state parliaments in Australia enacted legislation requiring judges to warn juries that delay in complaint was not necessarily indicative that the allegation was false, and that there may be good reasons for a complainant to delay making complaint. A joint report by the Australian, New South Wales and Victorian Law Reform Commissions stated that the effect of these provisions was undermined by a decision of the High Court, citing specifically the High Court's decision in Crofts. Now, Crofts was decided in 1996, and it concerned the content to be given to a direction to a jury on the significance that the jury might attach to delayed complaint in the context of the amendments which were made to the Act designed to fix up that area of the law. The relevant section of the Act stated that if in the course of the trial evidence was given or a question asked or statement made which suggested that there was a delay in making a complaint about the alleged offence, the judge was required to not just direct the jury, required to warn the jury that delay in complaining does not necessarily indicate that the allegation is false, and to inform the jury that there may be good reasons why a victim of a sexual assault may hesitate in complaining about it. The first complaint in Crofts had been made by the complainant to her mother 6 years after the first alleged incident and 6 months after the last. Notably, the court stated that the measure of cases of this kind, or by the measure of cases of this kind, this was, the court said, a substantial delay. It is now commonly accepted, and this has been confirmed by more than 3,000 people who've come to talk to the Royal Commission in private session, that in the context of child sexual abuse, the typical period of delay is likely to be more than 20 years. The court in that decision in Crofts held that the legislative amendments had not abrogated the common law requirement to give a direction about delay. Failure to give a direction that delay in complaint was a relevant matter in assessing the complainant's credibility meant that the direction given by the child judge, so the court said, was unbalanced. The court said Parliament had simply intended to correct what had previously been standard practice, by which, based on supposed human experience and the experience of the courts, judges were required to instruct juries that complaints of sexual misconduct were especially suspect. Those complained against were especially vulnerable, and delay in complaining invariably critical. The court said, in restoring the balance, the intention of the legislature was not to sterilise complainants from critical comment, where the particular facts of the case and the justice of the circumstances suggested that the judge should put such comments before the jury for their consideration. It may well be that Parliament intended to preserve the capacity for judges to make critical comment, but any critical comment must have a firm factual foundation. What we know about delay in complaint in the context of sexual abuse through empirical research tells us that there is no legitimate rationale for assuming a nexus between delay and the falsity or otherwise of a complaint. The law with respect to delayed complaint has been additionally disadvantaged to complainants as a consequence of another decision of our High Court in Longman and the subsequent decisions that confirmed and extended the application of that case. In Longman, a period of more than 20 years had elapsed between last alleged assault and the first complaint. The alleged abuse occurred whilst the complainant was aged between 6 and 10. Longman determined that a strongly worded warning should be given in circumstances of delayed complaint, as the accused would have inevitably suffered a forensic disadvantage which the jury would not be aware of without the assistance of the judge. The classic formulation of the Longman warning includes the phrase, dangerous to convict, expressed as that the jury should understand that it would be dangerous to convict on the uncorroborated evidence of the complainant. When that direction was given, as you can imagine, convictions were quite rare. The precise content to be given to a Longman warning was a matter that judges had some difficulty grappling with. The warning set out in the joint reasons in that case was complicated by observations made by two judges, Justices Dean and McHugh, in their respective judgments as to why they each felt a warning was necessary. Now, Justice Dean, who is seen as a very significant figure in the development of the common law in Australia, in that case, however, had this to say. He said the possibility of child fantasy about sexual matters, particularly in relation to occurrences when the child is half asleep or between periods of sleep, cannot be ignored, and stated that the long passage of time can harden fantasy or semi-fantasy into the absolute conviction of reality. And of course, His Honour was speaking with respect without the benefit of any psychological learning at all. He was just drawing upon his common sense. Justice McHugh stated that the fallibility of human recollection and the effect of imagination, emotion, prejudice and suggestion on the capacity to remember is well documented, and that recollection of events which occurred in childhood is particularly susceptible to error and is also subject to the possibility that it may not even be genuine. For these passages, Justices Dean and McHugh cited no judicial authority. More importantly, Justice Dean cites no scientific or extrajudicial material for these propositions. Justice McHugh cites a single book. It's called Memory, published in 1964. These observations, disadvantageous to complainants, especially complainants who were children at the time in which they were offended against, were subsequently shown by evidence to be of very doubtful accuracy. The decision in Longman and in Crofts have had profound consequences for complainants in sexual assault cases, particularly complainants who were children when the assault occurred, consequences that can be seen to flow directly from what judges thought they knew about how genuine complainants behaved and what they thought they knew about how memory worked. Assumptions that turned out, with the benefit of empirical research, to be quite erroneous. These assumptions became embedded in the fabric of the common law and, as we've just discussed, proved difficult even for Parliament to completely dislodge. I'm glad to be able to tell you that the decision in Longman and the requirement for judges to give a warning of that nature, that it was dangerous to convict, although they had a significant effect on conviction rates, have now been put to one side by Chief Justice Spiegelman in the Supreme Court of New South Wales in a case called JJB against the Crown. His Honour, however, had to go out on a limb in departing from the High Court, and did so with the benefit of carefully referenced footnotes to the research which he had himself consulted, although of course it was not research which was in evidence in the case at its trial. Justice Spiegelman doesn't stop to pause to identify how it is that he can legitimately have regard to that research, and as I've sought to explain, there may be real questions as to whether he can, but nevertheless he did it, and he did it because he was persuaded that the research which he'd read in comprehensive fashion was at odds with what the High Court had previously determined. Where observations are made about human nature, and these observations go on to inform the law and its practical application, judges must work to ensure that the observations are accurate. Where science progresses and the law lags behind, which is almost inevitable, the criminal justice system risks inflicting injustice on either complainants or the accused. However, it is apparent that the law, at least in Australia, has not yet identified the rules which will allow the scientist to speak effectively to the judge. I've referred to occasions when judges of the High Court, that's the Australian High Court, without consideration of the appropriate rules for their reception, have embraced the work of psychologists to assist their understanding of human behaviour. But the random nature of these references emphasises the need for some agreed rules about the appropriate approach. A trial within a trial, particularly at the appellate level, is not a particularly attractive proposition. But rules which are not informed by science run the risk of undermining community confidence in the law. In my remarks today, I've attempted to provide you with some understanding of the complex problems which the law confronts in utilising the learning of other professionals, particularly psychologists, in developing the appropriate rules for criminal trials. These issues are of particular concern for the Royal Commission in relation to the complex issues of joint trials and the related issues of tendency and coincidence reasoning, as well as the assessment of harm and other issues of particular significance in the sentencing process. Now, I don't have time to discuss our current thinking, although it's in its early days, on those issues today, but all of these will be the subject of detailed consideration in our forthcoming reports, and I will speak about them on occasions throughout the life of the Commission. One of the tasks we have set ourselves is to do what we can, firstly, to raise this issue, which is fundamental to an effective legal system, but also, if we can, to identify or point, at least in the way, of developing rules which will enable the work of all of you who are professionals in your various fields to have that work recognised and incorporated into the effective criminal justice process. But otherwise, thank you this morning.